Association. It's your new bar association with now 20% more president. We are here for our new State of the Bench conference. We're appreciative to be in the presence of many of our judges of the Board of Judges. Given the President Judge's order last week, setting forth new standards of how we're going to be proceeding in court in the first 3 months of 2021, we thought it would be a great idea to have another one of these just to update practitioners on what to expect when you come to court, whether you be coming to court, on what sort of matters, and how the court will expect those matters to proceed. We are joined today by President Judge Bateman, as well as Judge Mellon, Judge Fritsch, Judge Baldy, Judge Trauger, Judge McMaster, Judge Finley, and Judge Bowman, as well as other members of court administration. Thank you all for being here. I'm going to turn it over now to President Judge Bateman for a few brief opening remarks concerning the court's order. Judge Bateman.
Thanks, Sean. Did you say 20%?
Approximate.
Apparently the camera adds more than 10 pounds. Thanks for having us. Steve Heckman, Steve Watson, Sherry Worrell, and Dave Gomez are here from court administration. We also have Dave Kratz from the prison joining us. He's joining us remotely. So if anybody has questions for the judges in addition to those other individuals, please feel free to try and forward them to Sean and we'll try to answer them. After meeting with the Board of Judges, we decided to issue the most recent order. That was based upon conversations that we had together, that we've had with members of the bar, members of the court staff, people coming in and out of the building, the sheriff's office, and also after Steve Heckman and I, and mainly Steve, consulted with AOPC, we were concerned that the information we were getting, we were concerned that we were going to get more and more people coming into the building in larger groups, and that the virus is trending upward in numbers, meaning that it's probably, we have, as of today, for example, there are 8,500 new cases that have been identified in the Commonwealth of Pennsylvania. We had been up to about 12,000 at the height. We anticipated those numbers going up after the holidays. And I think the projections from the state, from the governor's office and the administrative office of Pennsylvania courts still places that number going up to close to 20,000 per day. Based upon that information and all the other available information we had, we felt it would be time for us to take a step back and cut back some of the things we're doing, not shutting down the courts, but trying to cut back the number of people coming and going into the courthouse. We're waiting in the hallways or waiting in our courtrooms. So what we've done is we've eliminated for the next 90 days those mass court lists, massive court lists. For example, ARDs, the district attorney will be doing by mail. We're not going to have ARDs coming into the building. It's a large group. License suspension appeals, summary appeals, those things that traditionally have required dozens, if not, nearly 100 people to be in and about the courtroom at one time. We continue to place our emphasis upon keeping everybody safe and keeping the building safe so that people should not have a fear of coming into the building, a fear of getting the virus. So that's why I issued the order, is that we have basically been doing it a couple of months at a time. We felt that after the information we had from the state, and Steve will correct me if I'm wrong, I thought they told us to anticipate a very busy January and February, so we decided to make it a 90-day order extending the judicial emergency through the end of March. Now, one thing we've done this time differently than what we've done in the spring is we've allowed each division, if you will, or each judge, if you will, to have more influence into how he or she will conduct matters in their courtroom. For example, Judge Mellon, when he does children and youth, is almost all virtual, as I understand it now. Whereas in the past, we weren't really doing it that way. Judge Fritsch in Orphans Court has staggered his hearings so that they're scheduled throughout the day, as I understand. And each one of them will be able to talk to you in more detail, time permitting, in a few minutes. So those are the things that we're working on. Those are the reasons for it. And again, we are trying to keep people safe and keep the courthouse safe from the virus, and we're doing the best we can. And we hope that some of the changes that we've made that will accomplish our goal. So that's basically what I wanted to say, Sean. And I reached out to Sean and said we're always willing to meet with the members to talk about things, and he asked if we could do it right away. So I think it was a good idea to bring us all here, and we'll answer any questions you have. I guess if we can, I'd like to start with the virtual hearings. We have Dave Gomez and Judge Mellon here. I know a lot of lawyers are interested in that, and we'll get to it. And Sherry's here, so we're going to get to how they're going to get continuances of all those cases that they need. But if I'd like Judge Mellon to weigh in on how he does the virtual hearings. I think that'll eliminate a lot of questions going forward and might save us some time.
That's a good idea, Judge. And I'll point out, I believe, if I'm not mistaken, that the court's preferred video conference method is using the Blue Jeans platform. So I think Judge Mellon will be telling us more about how to use that. Judge Mellon, if you can.
Yeah, and then we'll maybe get Dave Kratz to talk about how they're doing it at the jail, and then we'll go around the room.
That's fine.
Thank you.
All right.
First, let me say, have a happy holiday season, everybody, and be safe.
He's such a party.
Okay. Now, Dave, can we mute everyone's microphone if they haven't done it already?
We just did it, Judge. Go ahead.
Everyone's microphone. There is my law clerk made a educational PowerPoint to the features of Blue Jeans and how they can be used by the court and everyone else. If you are interested in getting a copy of that PowerPoint, just send myself an email and we'll get it out to you after the first of the year. We'll send them out. Some of the features of the Blue Jeans and the way we are doing PowerPoint, we've struggled with a variety of things, and we finally figured out all the features of Blue Jeans that allows us to have multiple hearings on one line, not multiple lines. So the most important thing is first setting up the meeting. Make sure you provide to the administrative assistant who will be setting them up. As I understand it, each administrative assistant will set it up for their own judge, and they need the telephone number or the email. Some attorneys didn't realize, and we have a number of clients, children and youth, where they don't have computers, laptops, but they have a cell phone. We can go with a cell phone and they can participate from wherever they are. I've had them participate from their car, from the streets. I have to tell them they can't walk, from a variety of other locations, and participate in the Blue Jeans hearing. So you don't have to be at your attorney's office. You don't have to be on a laptop. You don't have to be on a desktop or whatever else they call it. It's as simple as if they have a phone. We now have asked children and youth, when we set these up, to make sure that all their clients have the availability of a phone, because it'll work that way as well. There's two statuses of the participants. When you sign in, you do not need a passcode. The only ones that need the passcode basically is staff and whoever's going to be running the meeting, because that's called the moderator. And they have various functions that the moderator can do, which the normal participant does not. So as long as they have the, I think it's just a login, but not the passcode, you will participate in the meeting. That gives total control of that meeting to the moderator. He can turn off everybody's microphone. He can do a variety of things. Can you have private conversations? Yes. If you look at if you ask for the PowerPoint, it'll show you how to do chats and things like that. You can have 10, 15 people on a time, and you wanted to talk to one of them. You can invite them to a chat, and you can chat to that one individual or the two individuals offline while everyone else is still doing what they're doing. You can also segregate groups of people. So for example, in children and youth, we now have, let's say, another hearing waiting to start in 10 or 15 minutes, and they're starting to sign on. They can sign on and we can segregate them to a room. We can have multiple rooms if there's multiple people waiting. And then we can bring one group back in at a time as we want to do that as well. So you want to look at the features on blue jeans as to what's able to be accomplished and not accomplished. And that's how you basically run the meeting thereafter. They call it a meeting, we call it a hearing, just like you would as if you were in court. We ask everyone to turn off their microphones before we start. And basically, if they need to turn on their microphone, we ask them either to raise their hand or give me a nod or somebody else a nod, and we'll turn it back on for them. I can see a number of attorneys that have already experienced it at Children and Youth. And if you get an opportunity to talk to any of the Children and Youth solicitors or attorneys, you can get an idea of how it works. It's been very effective. Hearings are a little different because you lose the emotions of it, but you certainly get the testimony of it. I don't know if there's any questions about it, but Dave, what would you like to tell everybody about blue jeans?
Just to follow up what you've already said, that's the key point, is having a moderator to drive this. I know I've been approached by several other judges because this will be kind of the first foray for them into using it, I guess either from chambers or from wherever. And the key point is having a moderator. If it's not going to be the judge himself, it has to be someone who gets comfortable with that system so they can move people around or mute people. Because I have a lot of judges say, well, hey, I want to have a sidebar. How do I do that? Well, it can be done, but you have to decide, are you going to be the person doing that, or are you going to delegate that to someone? And that person, whoever you delegate it to, really needs to get comfortable with the moderator role. As the judge pointed out, you can mute, you can do, private chats, all these other features that will really benefit you in a proceeding. Up to this point, we've predominantly done video with the jail where it's just a flat, they're in front of us and that's pretty much it. But given the circumstances the pandemic has put us in, you need more flexibility than that. And as you just stated here, how you can control muting the mic on it. If you go into your blue jeans thing, you as the owner of that license can configure it to mute all participants before they even dial it. So you won't have any, and in Zoom, they all can do that. So it gives you more granular control. Now, the only reason why I say you need someone like this, because Derek, a couple weeks ago, came to me when you were using the two systems. And I said, well, this is how you can toggle between the two. It's going to be a new year soon, and all of a sudden, I'm going to have 14 judges like, how do I do this? Determine who that point person is going to be, whether it be yourself, your administrative assistant, your law clerk, or your tips, well, it wouldn't be a tip staff, or admin clerk. And then once you do that, get them comfortable. Obviously, your staff is very privy in it right now. Maybe have them sit down with their cohort and say, hey, let's just show you the basics.
Chris, my law clerk, said he'll be happy to sit down with any of your law clerks and go over the PowerPoint. I've sat down with some of the judges, with Chris, and I'm thinking, Sean, do you want to send that signed up our PowerPoint?
I was going to ask Judge if we could have a copy of that. If you could have your clerk send that to me, I'll make sure it gets out to the members.
And if
Don't send me the emails.
Yeah, if need be, maybe we can get Dave to do a quick tutorial for some of them. But I think from our standpoint, if, as I understand the question, Sean, the lawyers would like to know if there's going to be a hearing done by Blue Jeans, how do we do it? The court will set it up. They just have to request it. With, for example, Judge Mellon will do it on his own. I don't know if other judges are doing it or not. I'm not doing it. I think for what I do, I don't really think it's something I want to do. I don't know what Judge Finley wants to do with criminal as well. We do, obviously people that are in custody, we're going to do it for, and maybe that's a good way to let Dave Kratz weigh in and tell us how clients or how lawyers can meet with their clients down at the jail and set up virtual hearings or virtual conferences with their clients. So, but I think from a practitioner standpoint, they should make inquiry of the court directly, not the judge himself or herself, but to the judge's chambers. Do you provide for virtual hearings? If so, what's the procedure? And I think that's the best way to handle it.
And that's what I was going to ask, if it's to be done through judges' chambers, it's through court administration.
Yeah. I think it's judges' chambers. Some of us are doing them, some aren't. I'll do mine from the jail. I don't know, Judge Fritz will tell you what he's doing in a few minutes, because he does a combination of virtual hearings and phone conferences. I just don't think it works well for what I do in criminal court. It's hard to send somebody to jail when they're on the videos.
And I'll let everybody joining us know, if you check the chat, back in June, the Bar Association actually did a 1-hour CLE presentation on as a Blue Jeans primer, because the court utilizes that so often here in Bucks County. I put the link to the CLE from YouTube in the chat. Feel free to go visit that and take a look at that. That's a good primer that should help you get up to speed, where you could then start talking about, with Judge Mellon's presentation, how the actual handling of that hearing will work. But between that YouTube video and Judge Mellon's PowerPoint, which we're going to send out, you should have a lot of material to deal with that.
All right, thank you. Can we hear from Dave Kratz now? I don't know if he has other matters to get back to, but I'd like Dave to weigh in. And thanks for joining us, Dave. I know that things are busy at the institution, and if things are busy there, that means you're likewise busy, but I do appreciate you giving us some time. This is important to all of us. So I think the questions for you are basically, how do lawyers meet their clients virtually? How do they set up a conference? What can they do to stay in contact with clients at the jail, especially when we know that there's COVID from time to time that causes the jail to be in a virtual lockdown, or in clients may be quarantined. So I'll let you just give us a brief summary of what's going on and answer those questions.
Thank you. Good afternoon. So essentially, this hit us pretty hard and fast. We were in the process of developing video court, and COVID hit back in March, and everything shut down. So we had to react. We leveraged some CARES money. We were able to put some equipment together, and we pretty much enacted a video court out of nothing in about 2 weeks to just get the job done. Since that time, we've gotten better with our video court equipment. Unfortunately, we were in a long period of a modified lockdown / quarantine, and we are back in that current condition right now, where everybody is really having some cell restrictions and limited services. So currently, right now, your video court, your hearings, they're all being done on the modules. We're moving these mobile courts around and handling that. As for attorney and client conversations, there's a couple ways. Because of the pandemic, every offender is now getting a one free 10-minute phone call. So they can use that how they choose. Some are choosing the attorney, some are choosing other options. I would highly recommend we send out a letter to all members of the bar to opt out of phone recording. If that's something you have not done, please request that from me. Sean has my email address, a number of you do. You should register your cell phones. You should register the numbers that you receive official calls from clients on there, so that is not recorded. So that would be one way they can use their own phone, their own funds, or that free call to contact the attorneys. The other thing we've been doing is we've been running cell phones. We acquired some stripped down cell phones, and about 2:30 every day we've been running the phones around to the clients at the attorney's request. And unfortunately, batteries are limited, signals are rough. It really takes a toll on the phones. So we're asking that the attorneys, limit their calls to be as quickly as possible, a 5, 10, 15-minute max call, so that we can get everybody in. That demand has surged in the last 2 weeks. So we're trying to keep up with that, and we're expanding the hours out as well. Another way is the old traditional way. You can still come into the jail. If a person, I would recommend calling first, making sure the person is not on quarantine, that they can meet with you safely. Obviously, if a person is COVID positive, you may choose not to be in an interview room with them. You may want to wait that out a couple days till they clear. All the new admissions coming in are going through testing. So we're testing at the door now with a rapid test, and we're following that up with a serum test 7 days later. Usually new offenders who test negative and negative are out of quarantine around day 9 or 10. There is still cell restriction though. They're moved to a non-intake block, and they're locked down on that block. They're out for showers. I don't want everybody to go crazy and feel like their needs aren't getting met. Meals are being served on the module. So you try to get rid of that commingling. So we're running those phones around as well, but you can certainly come in and request a visit. I would suggest calling first to make sure that person's not active. It could be a wasted trip. Another thing we've done, we've taken our visitation rooms, since we're not doing public visitation. They are non-contact booths separated by plexiglass with a phone. We turned the recordings off for a number of those phones. So you could come in and sit on one side of the plexiglass and you could have a conversation with your client that is not recorded. We did, during the first lockdown, put some hours out. I am in the process of revising that now, getting that information out, because there is more of a need. We didn't have much of a need in the last month or two since things opened up, but now that we're back down to where we're at with the COVID situation, we are currently going to expand that out. So that's another option. The last option, and we reserve this right now for the very high-level cases. I don't want to minimize anybody's case. I know it's life and limb, no matter if it's a speeding ticket or criminal homicide. But some of these bigger cases where there's a lot of prep, we've been making arrangements to do some video link-ups at night. And again, we don't want to do that for these lower-level cases. But if you have a higher-level case, we're trying to arrange nights and weekends to do some video link-up. And we'll be formalizing that and expanding that out some more as well. Until this modified lockdown ends. So that's kind of where we're at. And again, we're doing a lot of video every day. Everybody's adapted pretty quickly. We're doing a lot of out-of-county videos. I'm in the process of setting up some more hours for attorney consults. I need to get some more contact information out, and I found the best way last time around was through the Bar Association. So we put some out. We'll put some stuff out to Sean with contact information and emails. We ask that you be patient. It is a little crazy in there. The changes that have happened in corrections in the last 6 months are things that decades have not changed. The way we do business, the way we're caring for people medically, everything that took 5 minutes now takes 25, 30 minutes. So everybody's been patient. We appreciate that, and we're just going to continue to move forward and do the best we can with getting everybody in contact with their clients as quickly as possible.
Dave, we just received a question. Are there transfers the transfers going out to other jurisdictions from the jail?
So, again, that's jurisdiction dependent. What we find is, and this is good for all the criminal attorneys, everybody will call me and they'll say, okay, my guy or girl has something in Montgomery County. Do they really want him? The answer is we don't know until the Bucks matter is disposed of. So if the Bucks matter is, adjudicated or bail's paid, then we reach out to that jurisdiction and ask them. And they have been doing video link ups, parole violations, the lower level offenses. They've been mostly releasing them. We've seen a lot of those releases or low bails, and we're facilitating bails for other jurisdictions as well. So yeah, I mean that is it's jurisdiction dependent. Some jails were hit harder than others. Some are not taking people in or out. Some are, but it's changes by the minute, much like it did back in April and May.
All right,
Sean, I think it's important that lawyers also know what Dave just referred to, and that is we can have hearings from other with inmates in other institutions. A lot of times when lawyers will tell us, well, my client's in state or in another county, and we can get that set up.
I've experienced hearings with state prisoners before. I wasn't aware that we were able to do video hearings with other county lockups.
So, yeah, we're
Is that
doing
jurisdiction dependent as well?
What's that?
We're clearing out a lot of out-of-county cases every day. Monco, Lehigh, Northampton, Chester. Philly is the sticky wicket. They really don't like to do anything with video. But we've cleared out a lot of those cases. They are receptive and open to doing video, and especially at the MDJ level as well. So you can reach out to those jurisdictions and you can arrange video. The one silver lining of all this is we all got very, very smart on video equipment really quickly. And we all expanded, all of our county correctional facilities expanded our video use, 100-fold. So that is available.
For those of you following along with us on the video, I did just send out in the chat to everyone Mr. Kratz's email address. I'll tell you, in the last few months, when I needed to contact a client in jail, he and his office have been very receptive and very helpful in getting me in contact with them virtually very quickly. So thanks from all of us that practice criminal law for helping us to do that. And I'm sure the people will be in touch with you if they need to talk to their clients going forward. Thanks a lot.
They will now that you gave out his email address.
Well, he said you have my email address, so.
Yeah, Sean, I will also say, I just saw a question pop up about Zoom. So again, our video courts we're using Teams, we're using Zoom, and we're using Blue Jeans. So all that is available for everyone.
Thanks, Dave.
Thanks, Dave.
All right, Sean, you want to just go through some questions that you think?
Yeah, I sent out a request to the membership for questions. We've already been through a lot of the general questions regarding how the court is going to proceed. I have practice area specific questions now. Let's just start. I got quite a few for family court. In family court, will the family court still be having non-emergent hearings, i.e. custody support, ED, in person or virtual? Judge Master, I guess that's for you.
Well, let me break that down into a couple of different groups. As far as the master is doing all of their conferences virtually. When it comes to a hearing, then that hearing is up to the individual judge, how they're doing it. Judge Mellon, for example, is doing everything by video. The individual judges have the option of how to handle them. Some are doing them by video, some of them are doing it in person, scheduling them, spreading them out, so the number of people coming in. I, for instance, in my January calendar, have a lot of whole day hearings so there was only going to be one set of parties there. Non-support, we are finishing up on doing contempts. We're not going to be scheduling contempts in January. We'll be doing contempt conferences, not contempt hearings, so that will reduce the number of people. And the state has given the domestic relations offices throughout the state video conferencing program. It's different from Blue Jeans, but the domestic relations office will set it up in the courtroom and do it when we're doing that. We're doing some things by telephone. PFAs, I'm having a meeting at 3:00 today to deal with Kim Litsky and Hillary and Stacy from the Pathonatory's office.
None of us likes to deal with Kim Letsky, Judge.
Well, I'm going to, so. What we're trying to do is figure out ways that we can eliminate the number of people that have to come and or stagger them, much like we did back in June when we started up. But that's a plan in progress right now. So it depends on what you're dealing with, be it non-support, be it family court stuff from the master's office or from PFA, how we're handling it. But the goal is to limit the number of people who have to come here for conferences. They're just all virtual. But for hearings, we're going to limit the number of people who are here at any given time so that we can maintain social distancing.
We got a couple of questions from practitioners. Due to the late release of the court calendar, I'm receiving orders for hearings with only 1 week's notice. It's very difficult to be prepared for a custody trial with such significance and mark exhibits and exchange them with only 1 week's notice. Is there any way that this can be avoided or prevented from happening in the future?
Well, it's an ongoing problem. We have a backlog of things. So as soon as a calendar comes out, we have to use that time. Because of this whole crisis, we weren't sure what was going to happen in January. So there was a delay in getting the January calendar out. I mean, I'm sure Sherry's going to do whatever she can to get things out as quickly as possible, but we're dealing with a constantly changing situation. We can't just plan like we did, a year ago.
Well, hopefully that will be resolved as we move forward. I knew this was going to happen and I wasn't sure how it would impact the calendar. So I did ask Sherry to hold off for sending out the calendar. We weren't sure what we were going to be able to do. For example, the masters were working virtually a couple of weeks ago. We knew that was coming. So to the extent that the orders came out late or were given on short notice, hopefully that won't happen moving forward. But, because of the really the delay in my decision on how to handle this, the calendar was necessarily delayed. So, I apologize for that. There are just so many other things that we had to take into account. Other courts are involved in this. We had, judges had other things that were scheduled. We were trying to get a lot of pre-assign things done because we knew we couldn't schedule them. We tried doing jury trials and all of this. So for a variety of reasons, it was delayed, but hopefully it won't happen going forward.
Thank you. In equitable distribution matters, where at least one party is pro se, can the court provide any time projections for when the master's office might plan to schedule ED hearings?
I don't have any, be honest with you, I can't answer that question at this time. I'll try to get an answer and get it to you.
Okay, thank you. This is more of a general question, more so than family court, but it applies, I think, across the board. How does the court prefer that exhibits be handled for a Blue Jeans hearing? Would the court prefer that they be exchanged among counsel and also shared with the court in advance, pre-marked and ready to be displayed? In furtherance of the comments of Mr. Gomez regarding administration of a Blue Jeans meeting for hearing purposes, who'll be in charge of making sure that the exhibit is placed on the screen? Is that something that the court's personnel will do, or is that something that the practitioner should be prepared to do?
Blue Jeans has a feature called screen share, and it requires a little bit of knowing how to do it, and then you don't have to produce them ahead of time. Until people get used to it, I have asked for my hearings is that they exchange documents and send them by electronically to my office, and they can refer to them that way. Everybody should just download them to their laptop and they have it. As we get more sophisticated, however, that won't be necessary because you have the screen share, which will allow you to put them up and show them and work with them like you were if you were on a podium.
I find when I've done that, Judge, it helps to load up all of your exhibits as tabs in a PDF editor, and then you can just click between the tabs to display whatever you want.
Yes, yeah, I agree. And for those of you who did not understand what Sean just said, feel free to give him a call and he'll explain how you do that. This is very efficient.
I'd be happy to. The next set of questions I have relate to the criminal court matters. A lot of practitioners have received documentation from the district attorney's office regarding AARD, which, as I understand it, is administrative ARD. Judge Bateman or Judge Finley, it might be helpful to give a very brief synopsis of what that program entails if you have it, or at least advise us. As I understand it, that program is only for 1 year ARDs, and the shortened accelerated ARD cannot be achieved that way.
Yeah,
Am I correct?
I'm not sure either one of us knows any more than you do about it. I don't know if Judge Finley wants to weigh in. I know it's administrative ARD and it's done by mail to the DA's office. We approved that because we didn't want 80 to 100 people coming into the courthouse at one time. Other than that, I don't know, do you?
I don't know anything more than that either. I mean, we've been working closely with the PD and DA to try to limit the number of people in the courthouse, and that was something they requested. Judge Bateman signed off on it, and pretty much that's the extent of our involvement.
Yeah.
And what sorts of criminal hearings are being held in person versus virtually? For example, bail hearings. Are bail hearings still being held in person?
Bail hearings or
Well, bail petitions.
bail petitions are still being done in chambers.
Okay.
But we don't have the parties there. So we have a representative from the DA's office, from the probation department, and then the defense attorney, be it the public defender or a private attorney.
I'm doing most of mine in the courtroom. I'm doing very few virtual hearings. As I said, the only hearings I do virtually are with defendants who are already in custody and they're set up through the institution or another institution. I don't know if Judge Finley's doing anything differently, or Judge McHugh's not here and Judge Gibbons isn't here. I don't know how they're doing it. Judge Fritsch has been doing some criminal. I don't know if that's how he's doing his criminal hearings, but maybe you want to hear from Judges Finley and Fritsch. I'd be happy to turn the microphone over to them.
And we can either get to those, and I'm happy to do it now, Judge, if you have Judge Baldy, Judge Fritsch, if you'd like to handle those with how you'd be handling those in civil court and orphans court, or would you like to get to those when we do the topics of orphans court and civil court?
Probably better waiting for the topics.
That's fine. I'll cover it then.
So I don't know if Judge Finley's doing anything virtually other than those defendants in jail as well.
just people in the correctional facility.
Yeah. Yeah, I think I don't want to speak for everybody, but I think it's more important we have them in the courtroom so we can see them and assess them. And also, as I joked earlier, sometimes you just have to, there may be a mandatory sentence, they have to be here. You know?
How are guilty pleas, for example, being scheduled? Obviously, you're not, based on your previous comments, you're not going to do them en masse anymore for the time being. Are they being scheduled individually?
Judge Finley and I met with the district attorney and the public defender, and Sherry was there as well. I don't know, Steve was there. So we all had a meeting with them. What they're trying to do is cut down on the number of people coming in at one time, as I said. Correct me if I'm wrong, but I think what they're doing now is they're working cases out ahead of time. They will notify us or notify Sherry what cases are resolved. And then the other matters that are not resolved or they haven't heard back from by a certain deadline, those matters will be continued to a date in the future. That way we don't have 10, 20, 30 people coming in asking for a continuance while they all sit around in the same courtroom, much like we're sitting here now. Imagine with 20 more people in it. So I think that's how we're handling it. If there's a non-jury trial that they're ready for, once they're ready, I guess they'll contact Sherry. She'll notify a judge, whoever's assigned to it, and that judge will schedule it so that they come in and do that on a given date and time. Other than that, I don't know if we've really worked through any of the other issues, but we're continuing to do so. I think, this happened right before the Christmas holiday, so we had very few cases coming in. I think going forward, we're going to have further discussions. I think we're going to, right now, as you know, we do guilty pleas twice a day. There are two lists, 9:30 and 1 o'clock, and those get assigned, or 1:30, depends on, it says they're listed for 1, but we usually take the bench at 1:30. So that's how we're doing them. I don't know, anything you want to add, Judge?
Well, I would add that essentially every case of an incarcerated inmate who was awaiting trial has now been pre-assigned to one of the judges who regularly sits in criminal court. Each judge will handle that separately. As an example, and I think is what most are doing, I have sent out notices of conferences in each of my cases where I will most likely do them by phone or in person. I'm okay with either circumstance to find out the status of the case. I've been assigning dates of completion for pretrial motions, then fixing dates for pretrial hearings, all trying to do everything that I can on those cases during this interim period, January through March. And I think that's generally what Judges Bateman, McHugh, Gibbons, Gilman, and if I forgot anybody, I apologize, but I think that's pretty much what everybody is doing on those cases. We're doing everything that we can. Let me suggest this to the private bar criminal practitioners. Use the telephone, call the DA's office. If you know the status of your case and you can accelerate that into this down period of time, we will find a way to get your client in, get that case over with and resolved. And I hate to say it this way, but to some extent it'll be almost guilty plea by appointment. Because we're going to try to do everything we can to keep matters moving forward.
Yeah, Sean, I'm sorry.
Go ahead, Judge, please.
I like Judge Finley, I've scheduled pretrial conferences by telephone to try and see what issues are outstanding, what the motions are. Maybe we can get a pretrial, a date for pretrial hearings, and then it's hard to give a trial date when we don't know when we're going to be back doing jury trials, but we're doing it that way.
My recent conversation I had with one of the DAs about a potential jury trial, I was advised that jury trials are being scheduled out as late as May now. Is that correct? We know.
I thought it was April. Could be. There could be some May dates, depending on if those April dates are filled up.
That was my thought.
And, and lawyers, and I know I'm going to get a lot of negative feedback on this, but we really need to know when it's really a trial and when you're just posturing. I mean, we all know it, but it's really hard to manage the calendar if lawyers call every case for trial or say, put it on a trial list. Look, you need a continuance. That's fine. We'll give you the continuance. You're not ready to go. That's fine. Please don't tell us it's going to be a trial when we all know it won't be, because we have to list it as such, and then Sherry has to get it on. Now, we're going to May. She's nodding her head yes. So that was new to me, but we were trying to keep them in April. So just think about trying to get a trial scheduled in May. And what's going to happen next. Well, now we have the summer months and vacation months. We had, for example, we had 10 cases. I think Judge Finley took 10 cases and assigned them all out to be trials when we had jury trial dates. So we would have them come in, do the jury trial, we'd be done. 2 of them went to trial, and I think 7 went to a plea and 1 was continued. Of cases that were definitely trials, once again, we get to that point where all of us were assigned to a jury room. We were all assigned to pick a jury. And at the 11th hour, we're told, well, now it's been resolved. So I guess what I'm asking the lawyers to do is try not to just call cases for trial or put it on a trial list unless it really is a trial, because it's really making the task much more difficult to get things scheduled and to get them scheduled promptly.
And the best practice, if the DA and the defense counsel desire a non-jury trial, would be to schedule that through the calendar office and court administration?
Yes.
Thank you.
Yeah, and Judge Finley has a question.
Actually, I think most of us are also directing counsel, the district attorney, to submit a last best offer. I know my scheduling order has said before testimony begins on the date of the pretrial hearing, and then whether I hear an ultimate resolution or someone else does, that's an open play at that point.
Yeah, there's going to be a deadline. I mean, I can't emphasize it enough, Sean. If I hear one more time somebody wants a jury trial on a paraphernalia case, we all know it's not going to happen. So, put it on the trial list, and it's there, and then it doesn't get tried. So we're trying to just be more efficient, more practical with the way we're approaching this. If we have to, then we'll make adjustments going forward. But we're trying to give everybody the opportunity to come in, as Judge Finley said, and plead by appointment. If we can't get that done, then we'll have to go backwards, and I don't want to do that.
Is there can you just discuss with us the major changes, if any, to magisterial district justice procedure? Is it uniform, or is that left up to the individual MDJ?
Well, I think and I thought I saw Judge Duple on here somewhere. There he is. My understanding is it's fairly uniform, although I believe Judge Gambardella still holds court out in the parking lot, but everybody else is doing it inside virtually, I believe. I mean, where's Steve? Am I right about that? I think we met, Bob Pollock's unavailable today. He's unavailable this week. So my belief is he sent something out to the MDJs and told them.
Virtual hearing.
Yeah, they're going to do virtual hearings. So that's fairly uniform across the board.
Thank you. Let's move on. I have a few different questions for Orphans Court. Judge Rich, thank you for joining us. First, would you like to discuss the points we previously talked about how virtual hearings or hybrid virtual hearings will be held in the Orphans Court, what you're doing live and what you're doing virtually?
Right. Well, let me just say, first of all, that we have been having most of our hearings in person in Orphans Court. And we anticipate continuing to do that. Ever since the pandemic started, we've taken steps in Orphans Court to try to make things a little bit safer. We spaced out our cases throughout the day, so we don't have a lot of people in the hallways waiting to be heard at the same time. We've limited the number of non-essential personnel in the courtroom for hearings as well. Our courtroom also is a little bit segregated from other courtrooms on the second floor. Again, we have been handling most of our cases in person, and I would anticipate we will continue to do that. We have done some virtual hearings. Judge Trauger's done some fairly involved hearings through Blue Jeans in his chambers. I've done a hearing or two using Blue Jeans with Dave Gomez's help in the courtroom. So in special situations where attorneys feel particularly vulnerable, or if the case may involve a lot of witnesses, we have been having virtual hearings, but generally not. So with respect to requesting a virtual hearing, that should be done on a case-by-case basis. As has been mentioned by Judge Bateman, I think attorneys should just call our chambers, the assigned judge, if they believe that a virtual hearing would be necessary or safe for them. And then we will take steps to make sure that that happens by way of Blue Jeans primarily. And with respect to those hearings, we also would like to have exhibits ahead of time electronically. So that's something we would be requesting. But virtual hearings, again, in Orphans Court, we anticipate just doing on an as requested basis in the future from here until the hopefully the end of the pandemic.
Thank you. And Judge Trauger, are your courtroom procedures similar to Judge Bridges? Would you like, if practitioners desire a virtual hearing, they should contact your chambers?
First of all, I want everybody to agree to it, number one. Number two, if they all agree to it, with all the witnesses, then exhibits, I've asked that exhibits be sent pre-marked and overnighted or delivered to chambers in advance of the hearing. So the question I guess I have for my colleagues is, we get an Orphans Court file that comes from across the street, and we have to put original exhibits into the file. I usually have, what I've been doing is my staff will be in the courtroom and I'll be upstairs in chambers, and the exhibits, I'm asking my court reporter to do court reporter to do her job, Minnie Clark to do her job. So those are some of the details of it. I have told my colleagues I'm open to it. I prefer to go back to the way things were. I'm open to it, and I think attorneys need to be on the same page together about it.
Your comments, Judge, brought up an interesting question for me. I think would apply to all litigation. Would the court agree that if you're making an objection over a virtual hearing, that would be a wise idea for the court reporter that the practitioners state their name, and so it's clear on the record who's actually making the objection? Is that a good practice, or is it wasteful?
No, I think that's helpful for the record, certainly.
Okay.
And Sean, the other issue too with the exhibits, council knows what the exhibits are. So you can stipulate to your exhibits, et cetera, help move it along. That's another key part.
Would you like, if there's anticipated any difficulties over the admissibility of exhibits, would you prefer a motion eliminated to be filed ahead of time to address that?
I don't think it's necessary in a judge trial, obviously in a jury trial. But we can, if council can work together to stipulate the exhibit, if we see an exhibit that's going to ultimately not come in, that's not a problem. Okay, but I think it is a problem. I don't want to have the courts and the staff to be responsible for, some exhibits are multiple pages. You're asking us, I disagree with if it's sent electronically. I'm now holding your exhibits, whether it's a full and complete copy, and I'm marking it and putting it in the file. I'd rather have you send me the original exhibit. You understand what I'm trying to say?
Yeah.
That I think is an important part of it, at least from what I've been doing.
So the lawyers need to check with chambers to find out what each judge's preference is when it comes to exhibits if they're doing the hearing virtually. I think that's the bottom line.
Yeah. Judge Bridges, matters are already scheduled for a hearing. I'm sorry, actually you addressed this first part of it. So unless contacted, unless your chambers are contacted, practitioners should expect that the hearing that's scheduled will be held in person. Is that correct?
Yes, that is correct.
Okay. Will the Orphans Court Master still be holding discovery and settlement conferences? Will that process be continuing?
That will be continuing. There's no reason to stop that. And obviously, those conferences can be virtual, but certainly he'll be continuing to schedule those.
All right.
It may even be increased if we find that there's a need for it, then he'll be available to do more hearings or conferences now than he has been, I guess. But I understand he's been pretty busy.
Yes, with a lot of cases, major cases having to be continued, during some months. I think he's been busier than he otherwise would have been.
In regard to guardianship hearings specifically, and the statutory obligation for the alleged incapacitated person to be present unless excused for medical reasons, I assume, and I think in my experience since this all started, has been that the Orphans Court will certainly look upon any of those requests with a lot of care if the alleged incapacitated person should not be coming due to exposure or risk of exposure. Am I right?
That's correct. That would be looked at as any other medical situation that's dangerous.
Thank you. All right, I have a couple now for civil court. Judge Baldy, thank you. Could the court advise of the number of cases in the current civil trial inventory awaiting to be listed for trial, as well as the number subject to case management orders?
Well, the case management, I don't really keep track of in this sense. Those are now fully automated. Now we have a bucket of some that are not in that list. But those cases that have a case management number and a date are going to be pushed forward. From August 3rd to December 7th, we had 6 trial terms. We scheduled jury trials from August 3rd to December 7th, anywhere from about 35 to 42 in each of those periods. Not one case was not reached. There was one that was not reached by mistake, but we got it in the next term. We resolved, in civil court, some cases will not resolve unless you call them to the courtroom. During that 6 months, we resolved cases or the parties agreed to continue them. If both parties agreed to continue them, we continued them. But we resolved a lot of jury trials. We're not behind on our trials in civil, for the most part. There's going to be some problems down the road, but for the most part, if you've got a car accident case, a slip and fall case, or whatever else, we're still on track to get you in as soon as we open the door again. It's going to be the same rules as before, 8-member juries. If you want more than 8 members, you're going to be pushed aside, but eventually reached. You're going to be demanding jurors at your peril because you will be called with much less opportunity. But if you do an 8-member jury trial, once we start trials in April, you're not going to be way behind. So we will catch up pretty quickly, I think. The waiver trials, we're doing them now. And as far as virtual trials, there are virtually no virtual trials in civil court. It would only be the most exceptional circumstances that we would allow for a virtual civil trial. It's just not going to happen. We don't need them. The waiver trials, we can control how many people come in a courtroom. And I would urge you, and as far as settlement conferences, we don't force settlement conferences on people. You have to both, if all sides say that they want to come to a settlement conference, that they're ready, willing, and able to negotiate in good faith at a settlement conference, and that a judge will help get the case settled, we'll get you in quickly. You just got to ask. We'll get you in, and we got plenty of time to do it. Same thing, with waiver trials. If you've got a small jury trial, maybe you can convince the other side to knock it into a waiver trial. Boy, next several months, now would be the time to do that. You know, you have to press your cases forward. I would invite you if you press a case forward, get the other side to also call court administration and say, look, we just put this in here. We want to have a waiver trial. We understand that the waiver judges will bring us in quickly. We just want to give you a heads up, and we'll get you in as quickly as possible. There are waiver trial lists that are going to go out over the next couple of months where there's going to be 5, 10, 15 cases on a waiver trial list. You're going to be called in the same way as you have been before. The difference is going to be that going forward, we're going to have pre-trial phone conferences with all waiver trials, the same way we've been doing with jury trials. We did that before, and that seemed to work, that all trials get a pre-trial phone conference. I think that really stimulated a lot of people settling cases. So I think that the civil list we're doing pretty well on. So people ask about 208s. If you have a 208 and you want an oral argument, that's up to the individual judge. However they want to do it, speak to them. If you think that for some reason why you don't want to show up live for an oral argument, that's up between you and the judge who's got the 208. There is...
Judge, what judges are currently assigned or will be handling 208s and waiver trials through civil court?
All judges do 208s. 208s are pre-trial. All cases are assigned on a wheel to any and all judges. So we all do preliminary objections. We all get motions for summary judgment. We all get any of those sort of things. Now, it's true that sometimes some of those cases get complicated and they'll get shifted to somebody else who does more civil. All med-mal cases, there's a limited number of judges that handle pre-trial med-mal cases. But otherwise, all judges handle preliminary objections and things like that.
What about waiver trials?
Waiver trials only go to a couple of judges. I'm one of them. Judge Trauger is another one. Other people sit from time to time. But the waiver trials, we've not had any problem getting them in and getting them done. I just had waiver trials last week. So we will have waiver trials, as many as you want. Come on in, we got you. Got you covered, we'll give you a courtroom, no problem.
What's being done about cases that were listed between now and March the 31st?
They're just, as far as, I don't really get into the court administration, but they just stack them up. And then when we open the door again in April, they'll grab the top 30, 40 cases, they'll list them. Maybe it'll be 40 or 50 that'll get listed on a trial list. And what I have found is when we list them, court administration was very good in the last several months of giving me 2 and 3 judges, civil judges, from time to time. So we were always able to get the people in. So we would call jury, a lot of you know, you were called in doing car accident cases, slip and fall cases. Those cases were getting tried, and people who demanded a 12-person jury, there was almost none that did that. The one exception were medical malpractice attorneys, and then almost every single medical malpractice defense attorney has demanded a jury trial, almost everyone. And that is going to cause a road jam, which has caused a road jam. I did call in a couple of med mals with 12-member juries, one 14-member jury. One of the cases settled. Another one, there was a mistrial. So if you demand a 12-member jury when we're trying to open the door slowly, you do so at your peril. Don't think that you won't get called. You still may get called in. But the problem was I wanted to get the other 8-member juries done, and we did. As I say, there were effectively no cases that we didn't reach. So I expect the same thing's going to happen in April when the doors open up. If you're on the list, be ready to go. We're going to be trying your case. I think that covers everything. And arbitrations, I'm not sure what the status is of arbitrations. I never see them. Sherry, can you tell me what the status is with arbitrations?
Yes, we're not going to be doing any arbitrations now until April.
Until when?
April.
April, arbitrations, there will be no judicial arbitrations until April. You know, it's a great time for practitioners to really think about going to alternative dispute resolution. You know, I really urge you to do that. I'll tell you something else I would be willing to do, and I want you to think about this. The civil lit, talk to the other lawyers. I would be willing to sit on something that we would call mandatory mediation or a mediation, how do I want to say it? Or a binding mediation where you come in and I'm going to end up ruling and I'm going to put some number on the case. But you do it like a mediation process. If you come up with some ideas, now's the time for civil litigation to come up with ideas, alternative dispute resolutions and things. I'm more than happy to work with you to see if we can get people out there saying, how can we get these cases done? There are a lot of cases that have to get tried because you can't get it resolved. Well, maybe you can resolve it with high lows and all kinds of stuff. I'm more than happy to work with you on that. But it's got to be done productively. I'm not interested in spinning wheels. I want to know that there will be something purposeful behind trying some new method or technique. So I'm available. Call me.
Thank you, Judge. One last area that we should probably cover is juvenile court. Judge Finley, Judge Bowman. I don't have any specific questions that were submitted for juvenile court, but I certainly don't want to neglect it either because it's an important aspect of what the court does. Are there any changes to the juvenile court protocols or procedures?
I'm not sure I would know of any changes. It's all the same to me right now.
No, we are scheduling a morning list and an afternoon list. They're greatly reduced so that we keep a close eye on how many people are around, and we do everything we can to keep that low. Just about everything where a kid is in detention or a placement, they're all done by video, partly because if a kid is in a placement, there's a 14-day quarantine at either end where a kid doesn't get any assistance at all. It's like being in solitary confinement, so we discourage that. So just about everything is virtual when it comes to a placement, but we've reduced the number. We're keeping matters moving forward, but and frankly, the numbers are down.
That's probably a good thing. That's probably a good thing.
Yep.
One other that occurred to me as we've been talking here, and it probably implicates everything we've been talking about, but I wonder how it affects family court in particular. Judge McMaster, Judge Bowman, if you're doing hearings remotely, I know that Blue Jeans allows you to join a hearing either by video, like we're doing now on Zoom, but also by telephone. I assume based on the idea that the judge needs to judge the credibility of a witness that you prefer or mandate that a witness appear via video. Is that correct?
Yeah, it's up to the individual judge. I know most of us, especially in custody cases, want to see the people. So we're trying to do things either video or in person because we really have to judge the credibility and we have to see them. On the non-support side, we're doing a lot more things telephonically.
Is it, am I correct that it's dependent on the practitioner if they plan on calling witnesses who will be joining by video to obtain the proper login information from the court well in advance of a hearing to make sure their witnesses are prepared to actually join the hearing at the appropriate time?
Absolutely.
And it's going out with a hearing notice as well.
But it's intended on the practitioner to make sure their witnesses know the access.
That's right. If they're going to call a witness, they better make sure the witness knows how to get in connected.
Okay, thank you. I believe that's most of the questions. Oh, there was one other question, and this might be one for you, Judge Bateman. Not all district judges, I'm reading the question as written. Not all district justices are complying with the emergency order. 2 million landlord-tenant hearings are being scheduled at the same time. No arrangements for virtual hearings in many courts. How can we get your order enforced?
Sorry.
Well, I need to know about it, and then Steve Heckman and I, and perhaps Bob Pollock will speak to that MDJ individually. And if that message isn't heard, then we'll have to decide how to proceed. We sent something out a couple of weeks ago saying that we're requiring social distancing, we're requiring masks. I had a meeting with the district justices. I think Judge Duppel's on, and I think he was on that conference call or that Zoom meeting. I think it was pretty clear that we're going to proceed in that fashion. I can tell you what will happen in a criminal case. I've told the DAs and the public defenders in response to their questions, if they're uncomfortable and their people feel unsafe going into a particular district justice court, then they can leave, and I will either remand it back or the DA will refile. We've heard about landlord-tenant. We've had some complaints from one person about landlord-tenant matters, and we made it clear that we are going to continue with social distancing and requiring masks to be worn in and about the district justice courtroom, much like we do here in our courtroom. So I don't know what else we can do. If it persists, and we'll have to speak to that MDJ individually. I don't think that's necessary. So I don't know, maybe, what's that?
I'm sorry, I have two other questions once you're finished.
I was going to say, maybe Steve Heckman can weigh in on that. It's a great time to be the court administrator. I saw Mr. Paul, who's retired, couldn't help but noticing a big smile on his face as we're going through this. So.
A couple of other questions that have come up, they're primarily related to civil court.
Before you go on, can Steve,
I'm sorry.
can we have Steve weigh in on anything in addition to that? I think we've taken care of that. We don't know of any, I don't know of any district justice who's not complied with that order. So this is news to me.
We need to know specificity who it is. Obviously, it's not going to happen over this network right now, but they need to address us with their specific complaints either by email to me and Bob Pollock, and then we'll address it from there.
So if there's any issues in that regard, they should contact Mr. Pollock and yourself and see if there's any issues that need to be resolved.
Yeah.
Correct.
Thank you.
And I don't know if you want to hear from Judge Duppel on that at all. He's on. I know he's not the problem.
If Judge Duppel wishes to speak and when we can unmute him to talk, we're certainly happy to hear from him.
I guess, all right.
I can tell you that it would also help if defense counsel knows it's a waiver. Why are they even coming to our courts?
Yeah, well, yeah, that's right.
We're trying to limit the amount of people that come to our court so that we can have this social distancing. If it's a straight waiver on a case, it's a retail theft or something that's not really an issue where you're going to be trying to work something out with the DA. Send us a waiver of your preliminary hearing. We'll sign it and we'll send it up to the court. You don't even have to come. If you want to have your client come to your office, you can be there and we can do it by video. I do probably 40% of my hearings by video right now. I know some judges do more, some judges don't do as much. Unfortunately, with 18 of us, there's 18 different ways we do hearings. But I try to do as many hearings as I can virtually. And if you want to waive hearings, you don't need to come. We can do that without you there, which limits the amount of people who have to be there on any given day.
Thanks.
I think, Mark, the question had to do with landlord-tenant. How are you doing landlord-tenant cases?
Well, fortunately for me, I don't have that many because Doylestown doesn't have a lot of rental properties. So again, if I have tenants who, for whatever reason, say they're not physically able to come to court, we do them by Blue Jeans. If they do come, we schedule them where we only have one landlord-tenant case at a time. And I schedule them at 15-minute or half-hour intervals. Again, with the volume of landlord-tenant cases I have, I can do that. Judge Vislasi, with 400 some landlord-tenant cases, doesn't have that option. I don't know what she does, but I don't have issues with landlord tenant cases in my court only because of the small number of cases I have in that area.
All right, thank you, Mark. Really appreciate you weighing in on that. You had other questions, Sean?
Yes, some in regard to civil court, is discovery court still proceeding, and is it being done in person or virtually?
Discovery court is still proceeding, and it will be done in person.
And what about, during one of these in the spring, we found out that there were some issues with the sheriff's serving process, or ongoing issues regarding the sheriff's service. Is the sheriff's office currently engaged in doing what the sheriff does?
As far as I know, they are. Until we hear from someone that they're not doing something, no, I'm not really sure. It wouldn't surprise me somebody told me at one point that the sheriffs were telling people that the president judge had ordered them not to do something. That, in fact, never occurred. They took it upon themselves to do that. The prothonotary has from time to time done things and said things, and Judge Bateman and I have explained to the row officers that the courthouse is open, that there's social distancing required, that masks must be worn, but people are supposed to be able to file things in person or by mail or electronically if the office allows electronically. But no one's supposed to be required to do any of those things, and everything is supposed to be operational. From the court system, Judge Bateman, you correct me if I said anything wrong or misstated. I think that's...
No, we've had multiple conversations with the various parties that you referred to, and I've not heard of any problems.
Okay, yeah.
So once again, many of the issues that are being raised, we need to know about before we can address them and hopefully correct some things, or maybe there's, maybe it's an isolated incident. We don't know.
The other thing is, I suspect, because I've heard things inferentially from time to time, I suspect that people behind the counter who answer the phone will say things that their boss or chief does not know. So there'd be nothing wrong with I would recommend to you not arguing with someone, but simply saying, look, I just need some clarification, and get them to state specifically. If they're saying to you, we're not serving anymore, we're not doing this, we're not doing that. If you want to say, okay, well, how long will that be? And is there an order that I can look at, or things like that? Those are good follow-up questions. And then you can come back to us and give us a phone call, or send an email and let us know that you're being told that an office has been closed, or that some service isn't being done. Depending upon which office it is, either Judge Bateman or I or Mr. Heckman or someone will contact that office and say, what is happening here? We've received word, and we will find out what's going on.
Thank you. I think that's covered all of the topics we've got for questions. If any of the court has anything remaining that they'd like to interject or add to what's already been said, certainly we can do that now. Looking around the room, I don't think we have anything. So I thought I'd wish to thank you all for your time today. I appreciate it. I know the members appreciate it very much. This is very informative and helpful to those of us who practice here in Bucks County. We're grateful to each of you for your time and your dedication to keep things moving, even though the conditions outside the building remain difficult for everybody. Thank you very much. Thank you, members, for joining us. Have a happy new year. I will be obtaining the documentation that Judge Mellon discussed for us earlier, and we'll make sure to get that out to each of you so you have a copy of that if you need it. And we'll send with that a link to the YouTube video, the YouTube primer we have on blue jeans, so you can take a look at that as well. I'm Sean Gresh. Thanks again for joining us, and everybody have a great rest of your week. Bye now.
Thank you, Sean.
Thank you, John.